Hello everyone, my name is Al Parsai. I'm a regulated Canadian immigration consultant. I have an experience of over 9 years practicing independently as an immigration consultant. I teach immigration consulting diploma at Ashton College, and I also the author of the bestseller book 88 Tips on Immigration to Canada, which is available on Amazon websites. Today, I would like to talk about the topic of sponsoring spouses to Canada. The sponsorship of spouses in Canada falls under a category of immigration called family reunification, which is defined under subsection 12(1) of the Immigration Refugee Protection Act. Family reunification on its own could be divided into three major groups. Group number one is for spouses and children. Group number two covers parents or grandparents, and group number three is about other family members. Unfortunately, under Canadian immigration system, sponsorship of other family members is extremely limited. But in certain circumstances, it's a possibility, but it is out of the scope of today's discussion. Today, I would like to talk about sponsoring spouses to Canada. When it comes to sponsoring spouses or children to Canada, on one side we have a sponsor, and on the other side we have the applicant. So the sponsor is a Canadian citizen or permanent resident of Canada who wants to bring his or her children or spouse to Canada. And the applicant is the foreign national who is not a permanent resident of Canada, who is not a citizen of Canada, who wants to become a permanent resident of Canada with the help of sponsor. So that's the case. But there is a lot more to that. So let's think about some concepts here and let's explain them one by one. So the first one obviously is about spouse. In the context of immigration to Canada, who is actually a spouse? So let's focus on that. So there are actually three different kinds of spouses in terms of immigration to Canada. And they all fall under subsection 117(1)(a) of the Immigration Refugee Protection Regulations. The first group are, let's call them just a spouse or official spouses. This means that they are two people who have got married officially anywhere in this world. When it comes to immigration to Canada, the immigration authorities consider a marriage valid if it is valid by the local laws. So let's say two people go to Malaysia and they get married. If the Malaysian government or the Malaysian laws consider this marriage a valid marriage, then immigration authorities will accept that as a valid marriage. In fact, I've had clients in the past that they were from two different countries and they end up in a third country to marry each other. An example would be a person who is from Iran and a person who is from Afghanistan, and they ended up marrying in Turkey. And that was one of my actual cases. But because their marriage was valid in Turkey, the immigration authorities accepted that as a real marriage. Unfortunately, the government of Canada does not accept marriage by proxy. Marriage by proxy means that one or both of the spouses are not present at the time of the ceremony of marriage. So it's important that both of those people, they need to be in the same room, at the same location when the marriage takes place. Or, unfortunately, the immigration authorities will not accept that marriage as a valid marriage. So that's an important issue that you need to keep in mind. Now, keep in mind that there are some exceptions to this rule. For example, for members of Canadian Armed Forces, but that's beyond the scope of this discussion. The second group of acceptable spousal immigration cases are common law partners. Under the immigration law, the common law partners are two people who who have lived under the same roof and they had this conjugal relationship or a spouse-like relationship. So in other words, they are not roommates. If two people just live together in the same apartment, it doesn't mean that they qualify as common law partners. They need to show that they had this spousal relationship or conjugal relationship with each other. And that could be done through several different documents. So cohabitation, of course, could be shown, for example, for a lease agreement for the apartment that was common between them, or their joint bank accounts, or their insurance policies, or a car that they own together, or their government IDs show the same address on them, those kind of things. And then in terms of intimacy, they don't really need to show explicit videos or pictures, but they can show some signs. For example, family members attest to their relationship, friends, they are aware of their relationship. Maybe they had some sort of ceremony to just recognize the commencement of that relationship, some affidavits they sign, etc., etc. So at the end of the day, they want 1 year of cohabitation, living under the same roof, and in a conjugal relationship or spousal-like relationship. And it doesn't matter whether this relationship is between two opposite sexes or the same sexes. The government of Canada obviously recognizes same-sex marriage. So two groups so far: spouses who are officially married and common law partners. The third group is called conjugal relationship or conjugal partners. Conjugal partners are partners that they have this spousal-like relationship, but for some valid reason, they are not able to get married, or they are not able to live under the same roof for at least 1 year. An example would be, let's say same-sex marriage is outlawed in a country, and because of that, and of course because of the societal conceptions and perceptions, unfortunately these two people cannot officially get married and they cannot even live together. So that could be a potential example. And actually the conjugal partnership piece was started to support those people. But it also could be because of some kind of immigration matter. So one spouse is in one country and the other spouse is in another country. They cannot, for some reason, leave their countries right now, or they cannot join each other in a third country to get married, or they cannot find a country that could officially help them to get married, or there are some sort of legal issues that prevent them from officially get married to each other. In those situations, if we can justify the matter to the immigration officer, then they will recognize that conjugal relationship. So 3 options for definition of a spouse. In terms of children, children are defined under 2 paragraphs of section 117 sub 1. It's paragraph B, which talks about dependent children. So basically those children that are children of the sponsor, they are under 22 years of age, and they also are not married. In some exceptional cases, if the child is more than 22 years old, we can still consider that child a dependent child, and that's when, because of a medical disability or issue or condition, whether it is mental or physical, that person is highly dependent to this sponsor yet. The other option is for adopted children, but the adoption process, which is defined under paragraph G, is a complex process because you need to go through several steps to prove to the government that this adoption is genuine. And the reason they have this in place is just to prevent human trafficking or exploitation of children. And that's why it's important that a person, a Canadian citizen or permanent resident who wants to adopt a child from outside Canada, they need to go through those processes, whether it is covered by the Hague Convention or not. They need to go through them to make sure that the adoption can be proven to be a genuine adoption and then sponsor their children. Okay, So we talked about the applicants, which is the spouse or the child. Now let's talk about the sponsor. Sponsor needs to meet certain, of course, conditions. Obviously, a sponsor is either a permanent resident of Canada or a citizen of Canada. That's no doubt about that. Also, the sponsor needs to be at least 18 years old. And by the way, when the sponsor is sponsoring a spouse, the spouse at the time of sponsorship also needs to be at least 18 years old, or you cannot sponsor your spouse. But going back to sponsor, so we're talking about a citizen or permanent resident of Canada who is at least 18 years old, and also a person who resides in Canada, and that's an important piece. The sponsor needs to reside in Canada. In fact, in the past, I've had clients that the immigration authorities sent me an email and requested of some documents to prove that the sponsor is in fact right now inside Canada. If they realize that the sponsor does not live in Canada, of course traveling is not a big issue, but if the sponsor is not living in Canada, that will cause problem and they cancel the sponsorship application. There is an exception to this rule. If you are a Canadian citizen, not permanent resident, if you are a Canadian citizen who is going to sponsor your spouse or common law partner and you reside outside Canada, then in that situation you might be able to sponsor them, but you need to prove to the immigration authorities that your intention is eventually to go back to Canada. And there are many documents that you need to show to prove that. I've had a few cases in the past that luckily all of them were successful, but it's a challenging thing. It's not that easy. Okay, so citizen resides in Canada, 18 years old. There is something interesting that you need to know. It's called the 5-year rule. So let me give you an example. Imagine that you are sponsored by a Canadian or permanent resident to Canada. And you come to Canada as a sponsored spouse, and then when you enter Canada, unfortunately, after a while, your marriage breaks up. Now, can you get married to another person outside Canada and sponsor that person to Canada? The answer is yes, only if at least 5 years have passed since the day that you became a permanent resident of Canada. So we have this 5-year ban on sponsored spouses to sponsor another person to Canada. Okay? Obviously, when you are married to somebody, you cannot sponsor another person by marrying them because we don't have polygamy in Canada. That's another issue that you need to know. And if you look at Section 133 and beyond, the regulations, there are some other limitations and expectations from sponsors. For example, if the sponsor is convicted because of domestic violence or because of certain sexual matters, then that sponsor is not a valid sponsor. These are for obvious reasons. They want to make sure that the lives of those foreign nationals are not in danger through some bad Canadians. So that's important to discuss those issues with your immigration consultant or lawyer or among yourself to make sure that this is a healthy marriage and will less likely result into any sort of exploitation. Okay? And one area that people may ask, and they constantly ask me this question, is about minimum necessary income. So normally when you're sponsoring somebody to Canada, for example, your parents and grandparents, you need to show that you've had certain amount of income in the past few years. The situation for spouses is different. Sponsors who are sponsoring their spouses are exempt from minimum necessary income, unless under certain circumstances that the spouse has some complexities in family structure in terms of having children and grandchildren and stuff like that. But generally speaking, and if the spouse have only one child, that's a different issue. So generally speaking, if those complexities are not there, then the minimum necessary income is also not there. Having said that, remember that whoever is immigrating to Canada Under Section 39 of the Immigration Act, they need to show that when they become permanent residents of Canada, they are able to or willing to be on their own and not to use social assistance. That's extremely important. In other words, if the officer thinks that, this sponsor is not working and the spouse is, say, an illiterate person, so how come when this person comes to Canada, they'll be on their own? That's why you need to show some documents to prove this is not the case. And of course, case by case, it's different. Sometimes, for example, we focus on the current employment status of the sponsor or education of the sponsor or the kind of activities they are taking right now in Canada. Sometimes we focus on the applicant, their education, their work experience, current work status, etc., or sometimes a combination of both. And we try to convince the officer that, in fact, the applicant is not inadmissible under Section 39. The other issue that I need to talk about is called undertaking. So when you're sponsoring somebody to Canada, you sign an agreement with the government of Canada that for a period of time, this person who comes to Canada will not use social assistance. And if they do, you as the sponsor are responsible to pay back that amount to Canada. Otherwise, you cannot sponsor other people to Canada, or you may even face some legal actions from the government of Canada. The undertaking for spousal cases by default is 3 years. Okay, but in certain cases, if, for example, for children, it could be up to 10 years, depending on the age of the child. So you have to be very careful with that, because if you sponsor somebody to Canada and that person comes to Canada and you split, and that person uses the social assistance, unfortunately, you're on the hook. And there is nothing, pretty much nothing, that can prevent you from being off the hook. It means that a divorce or other issues cannot justify not being or canceling that undertaking. So that's important to make sure that when you are signing that undertaking and you're sponsoring that, you are really into that and you really want to make this happen and this marriage is real. And that brings us to this moment to know that, in fact, the steering of the sponsorship application is to a great extent dependent on the sponsor. So the sponsor can, before the foreign national becomes permanent resident, can cancel the application at any moment of time. In fact, a few years ago, I received a phone call from somebody who was stuck in the airport because the sponsor had canceled the sponsorship application, and she came to Canada and at the port of entry realized that unfortunately the sponsorship application was canceled and she couldn't enter because the sponsor says, no, I'm not going to sponsor this person anymore. So that's one other area that you need to know. The other area is obviously the area of fake marriage or sham marriage, which I have explained that in a separate video. It's a short video, about 5 or 6 minutes. You can watch that for more information. But briefly speaking, sometimes the sponsor and the applicant are not really into that. And the main reason for the marriage is just for that person to come to Canada. Then normally, not always, but most of the time, some money is exchanged between them. The sponsor receives money and then in return sponsors that person. But remember the undertaking issue, and also remember that maybe that sponsor is not the right person and you are suddenly exposed to human trafficking, sexual exploitation, or other issues. So that's why I do not recommend fake marriages. Actually, I condemn fake marriages. Please stay away from them. Even when you become a permanent resident of Canada, or even if you become a citizen of Canada, if the immigration authorities realize that that marriage was not a real marriage, then they will come after you. So you have to be very careful. The last thing that I would like to discuss is the topic of appeal. Fortunately, for the case of immigration under spousal sponsorship, they have the right to appeal of the decision of the immigration authority. So if the immigration officer refuses your case, this is not the end of the story. You may appeal the decision to a division of Immigration Refugee Board called Immigration Appeal Division. So a seasoned immigration consultant or an immigration lawyer can help you to defend yourself at that court-like system. And if you win the case, because the Immigration Appeal Division has the authority to make the decision about your case, then it doesn't go back to the officer to approve you. You will be approved by IAD, and all you need to go through is like medical examination if it's necessary, if you need to renew it, or some other background checks, and if everything is in order, you can become a permanent resident of Canada. And sometimes the immigration officers, of course, invite you to an interview. Interviews are not that common. In the past 9 years that I'm representing clients under this group and other groups, I've had only 2 cases that they were invited to interviews. But it's important that at the interview, you prove to the officer that your marriage is genuine and the main purpose for the marriage is not immigration to Canada. If everything goes well, I can tell you that this is probably one of the easiest options for immigration to Canada. But yet, make sure that everything is in order, no misrepresentation, and be convincing, and hopefully you will join your spouse in Canada very soon. Thank you very much for watching this video. I hope you continue watching my video series of immigration training, and see you soon.